first I want to do is take care of some housekeeping. Of course, as always, on your screen, you will see the PowerPoint presentation in the center of your screen. There. This should take up most of your screen. There should also be a small box on the bottom right-hand side of the screen with the video feed, me, on the side, because we want to make sure you have the actual presentation in front of you. On the left side of the menu, please select the question and answer icon and type your questions there, which will be addressed at the end of the webinar. And please make sure you choose the one that says questions and answers, has the question mark in it, not the one above it that says conversations. That's not as monitored, it's not as fun, and generally speaking, if you're typing in there, it should be comments, not questions. So if you have any questions, please do type them in the question box with the question mark. That's also a more centrally located place. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report. And will be sent via email within 48 hours after the webinar. If you do have questions, let us know. These credits are, of course, not transferable. Please email education@altitude.law, or you can call Grace directly at 303-991-2076 with any questions you have reserving your credits, your CMCA credits, your certificates, or this presentation. We can obviously get this to you if you want a copy of the PowerPoint as well. So with all that out of our way, I again welcome you, and let's get on our way. So adult swim time and other no-nos for rules and covenants is the name of today's topic. Essentially, ladies and gentlemen, this is a discrimination case. This is a discrimination presentation on allowable rules, not allowable rules, the history thereof, and where we can go with this. So in starting off, I kind of tried to put together this in the old investigative reporting type thing, the who's, what's, where, when, why's, and how's. So since I didn't really go with the flow of this, we're going to start with the what. What's wrong with limiting kids, pools, and pets on common elements and common areas? Generally speaking, while you may see very valid reasons, and many associations have very, very valid reasons for why they want to adopt certain rules, unfortunately, we have that pesky thing based in federal law, which is the Civil Rights Act, the Fair Housing Act with amendments, the Americans with Disabilities Act. These federal statutes tell you it is wrong to prohibit kids to have adult swims, to have certain criteria or requirements on dealing with certain protected classes. I've got yes, PowerPoint, again, I will answer questions. I know I said I'd answer them at the end, but I actually prefer to have a dialogue with you. It's a little harder for me. I kind of tend to pace. If any of you have seen me present before, I tend to pace. I tend to like to be interrupted because we have a dialogue. So I want to make sure that you guys have the absolute utmost in this presentation. And it says, this may be covered during the webinar. I want to make sure I try to get this question just in case. I know it's not allowed to impose adult swim time only, which is true. You're right. But what about restricting times for specific activities? Okay, we'll get into that. So that's a great question. We'll get into it. So let's go with the why. Well, unfortunately, as we are experiencing right now, this country has a history of discriminating against protected classes, and which forced the legislature, both at the national level and local levels, to enact statutes to protect certain groups of population, certain minorities, certain minority interests. And they are, unfortunately, evidence of this came out in no diversity in neighborhoods with exclusionary practices. The associations or the builders wouldn't allow certain people to buy into communities. Redlining, where a bank would draw red lines on a map and say, we will not lend in these communities. So it deprived certain parts of the population with home ownership and the ability to earn wealth and gain wealth. They also did it through covenants. And they would we've got some examples later on in some of the more prime covenants that would actually appear in a set of declarations. And in doing some research on this, one of the ways that a developer or a group of people would discriminate or establish discriminatory practices was really through the adoption of what seemingly, and again, we can get into this in a little bit, on their face, non-discriminatory rules. The first set of no clotheslines in a community was actually not geared at the aesthetics of a clothesline in somebody's backyard. It was geared at excluding certain parts of the population from being included in the community, because only certain members of the population could afford clothes dryers. So by prohibiting outdoor drying or clotheslines, you, by de facto, excluded a certain part of the population from living in your community. So again, it's the purveyors of these restrictions got very creative on how they could discriminate and make it not necessarily look like discrimination. So again, we'll address some of those concepts in a little bit. Flat out no kids. Advertising markets or homes as good for empty nesters. Of course, there is that exception to that. HOPA communities, which are Housing for Older Persons Act communities, restricted to ages 55 or older. And I will tell you, that statute is blatantly discriminatory. It is federally mandated discriminatory statute, which allows for people to allows for communities to discriminate against people younger than 55. And the only explanation I have for that are the boomers had the money at the time this was passed. The baby boomers spent more on lobbying and were able to get the statute passed. It is a clearly blatantly discriminatory statute. It says so on its face, but it provides an exception. And that is the exception for the no kids rule, that HOPA communities are specifically exempted from violations of the Fair Housing Act, where they can discriminate against kids. You have to be at least 55 to live in the community. Board members are unfortunately not a protected class. It was a very good question, and as much as I wish it was true, no, board members are not protected. Which there's another class of people that are not protected, which we will of course get into in a little bit. So, moving on. You also have state discrimination laws, the Colorado Civil Rights Act, which is codified at 2434-501. It, by and large part, mirrors the federal act. Excuse me. Adds two additional characteristics for protected classes, such as creed. How creed is different from race is not necessarily clear to me, but the state went to protect the creed, and also protected LGBT, gay and lesbian rights. So, and transgender rights. So that's in the state statute. That's not necessarily in the federal statute. So, you now know the how and the why. Let's talk about the who. Who can be accused of discriminating? Well, anybody that pertains to the sale of a dwelling, the rental of a dwelling, or the use of a dwelling. Anybody that deals with those three general statements can be accused. And that's how you get into by homeowners associations. You regulate the use of a dwelling. The HOA manager manages the community, sends violation letters. That is how managers are brought into this. Boards of directors, they govern the association. They operate on behalf of the association. So when they say go enforce against this person, go send this letter. If it is they adopt the rule. If it's a discriminatory rule and they are trying to enforce it, that's how they get roped into this. Owners and others, and when I say owners and others, the Department of Justice issued 6 years back approximately, issued a statement that stated that the association must get involved if it is witnessing or has the ability to get involved with preventing discrimination from an owner-to-owner dispute. So owners can also get involved in discriminatory behavior, and by definition, it almost drags the association into it if it is discriminatory between an owner and an owner. It makes it very difficult for an association how to respond or how to react when it hears complaints of discrimination Normally, we would say, well, that's an owner-to-owner dispute that doesn't involve the association, but the federal government made it an association problem. So we actually have to take that seriously. We have to investigate it, and we have to take action if we possibly can, or it could give rise to a discriminatory complaint or a complaint of discrimination against the association. Okay, the how. How do you discriminate? Well, you attempt to enforce a rule that has a discriminatory effect towards somebody with a physical or mental impairment, which substantially limits one or more life activities, a record of having such an impairment, or being regarded as having such an impairment. So it occurs when you try and enforce the rule. And it occurs when you send a letter and say, dear owner, this is a no pet community. We see you have a dog, get rid of it. That right there, if this person has a disability that limits one or more life activities, a record of having such an impairment, so you either knew or should have known that this person had it, or they're being regarded as having an impairment. So even if this particular person exhibits nothing, but they've always been regarded as having that impairment, when you send that letter, that can give rise to a claim of discrimination. As we said, enforcement of rules against kids. It's familial status. Discrimination based on the familial status means the treating of certain people different than other families with kids. So if you are giving preferential treatment, and this kind of gets into that, the title of this presentation is Adult Swim. Well, you cannot have an Adult Swim only, because that discriminates. It treats people without kids better than the children, or it treats adults and gives them more preferential treatment to the community than it does the kids. So it makes it very problematic to try and navigate some of these aspects of the statute when all you're doing is thinking, well, the adults pay the bills, the adults are the ones to pay the assessment. They've asked us if we could just give them a little bit of time in the pool where they don't have to deal with kids jumping all over them. Unfortunately, you can't. There are strategies to deal with it, but you can't. And that addresses that, and we'll kind of get into that. So what do you do? Okay. There are generally two types of discrimination, or two types of discriminatory rules or treatment. The first is discriminatory treatment is where the victim is expressly treated differently than others in the community based on his or her protected class. The rule prohibiting children from playing on common elements is an example of discriminatory treatment because the rule expressly acknowledges that only kids are subject to the rule. So if you have a rule that says Adult Swim or no kids, or children can't do this, children under the age of 16 can't use the pool, that's on its face discriminatory, and it creates this rise of de facto discrimination. The other one's a little bit trickier. It's disparate impact. And discrimination through disparate impact occurs when a seemingly neutral rule has the effect of discriminating against a protected class. A typical example of this is discrimination is a rule that prohibits tricycles in the community. Right? Blatant rule. It just says no tricycles in the community. Doesn't single kids out, although it has a disparate impact against kids because adults tend not to ride tricycles. And therefore, it's going to be deemed discriminatory. When I talked briefly about the clotheslines, that rule, no clotheslines in the community, had a disparate impact against a protected class. And as a result, was deemed to be discriminatory. They were targeting out one group of people by this rule. Did it say they were targeting them out? No. Did it have that impact of targeting them out? Yes, it did. It went through that process of discriminating against a certain group of people, even though they were not mentioned in that rule. So when you're drafting rules, you have to look at exactly, does it name or is it discriminatory on its face? Does it say kids can't do this? Does it say this person can't do this? Does it say this person can't do this? All being a protected class. But then also look at it and say, okay, does it have a disparate impact? What's it really guarded? What's it really aimed at doing? What are you really trying to accomplish? And if you look at it and say, well, we're really trying to accomplish keeping kids out of the pool between 9 and 10, it probably has a disparate impact. And change, you're going to have to find a better way to draft the rule and a more appropriate way to draft the rule. Okay. Another part of our investigation into discrimination and the rules of no-no are the when. When does discrimination actually occur? Can you send the letter? Can you say, dear owner, it appears that you have a pet. Please understand this is a no-pet community. Please come talk to us about it. Does that give rise to a claim of discrimination? And discrimination is deemed to occur when you actually deny or attempt to enforce the discriminatory rule. So a letter or action that seeks to actually enforce the rule will give rise to a claim. Not a letter saying, dear owner, this is a no-pet community. It's been reported you have a pet. Can you please explain why you have a pet? Or can you please explain to us what's going on? That does not give rise to the claim of discrimination. And the bright line rule on this, if you will, came out of a federal case out of Hawaii, now about 10 years ago, where the association, where an owner moved into a no-pet community, had a pet, claimed that it was an emotional support animal. The association said, great, we conditionally grant you approval for this, but you need to provide us reliable medical information as to why you need this emotional support animal. They didn't deny it. They didn't try and remove it. They didn't fine. They just asked for more information. And the person, the pet owner, responded saying, well, here's my evidence. And it was not very good evidence. It was not reliable medical information. So the association said, thank you very much, but this isn't satisfactory. Can you please get us more information? So instead of getting more information, the owners, the pet filed suit for discrimination, saying that they were being illegally discriminated against pursuant to the Fair Housing Act as amended. And the federal court came down and said, no, they did not take any attempt to remove the pet. They did not fine you. They were doing their due diligence, and the association is absolutely entitled to do due diligence. The discrimination occurs at the time that you try and fine. Discrimination occurs at the time that you have made the decision that they are in violation of the rule and attempt to enforce it. So that's kind of how we go about that. It is, what do you do with that? You are allowed to investigate. You're allowed to do your due diligence. You're allowed to push back on these claims for emotional support animals, but don't try and remove the animal from the community while you're doing it. Allow the animal to exist in the community while you perform your due diligence. So that's the when. So let's get into actual examples. And again, I got another question on what about implementing a rule, for example, children under 12 must be accompanied by an adult to require adult supervision to use the pool and park. The pool may be because, again, you've got your rule can take into consideration reasonable life, health, and safety restrictions. So if you want to say something along the lines of children under 12 must be accompanied by an adult or require adult supervision, if those are the pool guidelines, if the manufacturer of the pool has recommended this, or the American Swimming Association has recommended that children under the age of 12 should not be allowed to use a pool without some sort of supervision, appropriate supervision, it's fine. You can't really call it adult supervision as opposed to supervision because let's say the rule for allowing babysitting is 15, and you have a 15-year-old babysitter who has passed the American Red Cross, CPR, and is taken a bunch of babysitting classes and is able to show that they can babysit. You have now prevented that competent individual from being a person that can watch kids at the pool. That would have that discriminatory impact. So it shouldn't necessarily require adult supervision as opposed to appropriate supervision. Again, what you don't want to make sure that you are not discriminating against somebody. I also prefer a rule that doesn't go at the actual age of the person as opposed to get the behavior. Are they competent swimmers? You can absolutely require everybody to pass a swimming test to use the pool without some sort of supervision and go about it that way. say you must be a competent swimmer, you must show us your ability to swim, and that way without using it. And then you can just adopt a rule that says competent persons that are not able to exhibit competent swimming skills may not use the pool unaccompanied. Something along those lines. Again, get at the behavior, don't get at the age. You know, you can have some 18, 19, 20-year-olds that have no idea how to swim and yet go jump into the pool and can cause all sorts of problems. Again, let's get at the behavior. Let's not necessarily get at the classification or a fictitious age of that somebody can't use the pool, can't use the amenity. So, getting into, okay, oh, I didn't actually read my rule. So this is an oldie and a goodie, and I actually pulled this out of a set of declarations we have on file. And it flat out says, none of the lots shown on said plats shall be conveyed, leased, or given to, and no building erected thereon shall be used, owned, or occupied by any person not of the white race. This prohibition, however, is not intended to include the occupancy of a person not of the white race while employed on the premise. So obviously, these were the type of covenants, rules that were flat out made illegal by the Civil Rights Act, made illegal by the Fair Housing Act. These are the type of things that were originally written into declarations to keep people not of the white race out. And this particular provision was drafted by some of the founding fathers, the city of Denver. The pillars of society in Denver put this in a set of declarations they drafted. Notice it was to ownership and occupancy, but it was not, you know, you could have somebody not of the white race there to live in and serve the person of the white race under their employment, but could not actually own the property. These type of restrictions were widespread in the mid-1900s. As the Civil Rights Act moved, people were trying to find ways to exclude people from living in their community, and this was unfortunately one of those sins of our past. Clearly discriminatory on its face. Okay. Another rule, children under 16 must be accompanied by an adult. Again, it's discriminatory on its face. You have listed 16. 16 is deemed to be an adult driver. 16 is deemed to be somebody who can take care of themselves and operate a motor vehicle, but you have now said they can't use your facilities, use your pool without adult supervision. Excuse me. It's discriminatory on its face. As I mentioned just briefly about the other question, I prefer something along the lines of all users must be proficient swimmers. If you look at some of our wonderful Olympic athletes, you know, they're getting to be 14, 15 years old, and they're out there tearing up the pool, setting world records in the pool. 14, 15, 16-year-olds can swim. And to not allow them that right is discriminatory and could get you into trouble. Another rule, children under the age of 5 may not use the pool. Well, great. That's doesn't even allow for adult supervision. It's discriminatory on its face. This, along with adult swim, clearly violates the FHA mandates. What you can do is, again, say children under the age of 5 may not use the pool unaccompanied, or children under the age of 5 may not be alone in the pool. You can also, you know, a lot of associations like to draft language of children, you know, not potty trained children can't use the facility. Well, with the invention of swim diapers and swim attire, you have to allow these children into the pool because it's discriminatory on its face. Also, the other problem you have is, and this actually came out of a federal lawsuit out of Florida, where the association had adopted a rule that said all children must be potty trained to use the pool. And the court flat out said it's discriminatory to limit that at kids, because presumably the reason you want them to be potty trained is so fecal matter doesn't get into the pool. And we have studies, and this court has seen studies of adult-only pools with more fecal matter in the water than in a kid's pool. And other than apart from making you go ew, it kind of gets to the fact that your rule should be along the lines of anybody that is not potty trained, or anybody that does not have full control of their bowels must wear appropriate swimwear or swim attire or swim diapers, you need. Again, get at the behavior, not at the age of the children. And again, as we just went by, children must be potty trained to use the pool as discriminatory on its face because it deals with kids. A much better way to draft that rule is all swimmers must have control of their bowels, or all pool users must wear appropriate swim attire if they don't have control of their bowels, or something along those lines. You're not getting at kids. Is the rule really kind of trying to get at kids? Yes, but it's not discriminatory on its face, because if you've got somebody that older does not necessarily have control of their bowels, they have to wear swimwear too, and that way you're across the board. You don't care who it is. If they can't control, they must wear it. Okay. Children should not be permitted to play or loiter in the stairways, hallways, elevators, entryways, nor in any storage, parking, or maintenance area. Again, it calls out kids. It says kids can't do any of these things. This is based on familial status. It's discriminatory on its face. My questions to you is, what are you trying to accomplish, and why are you limiting it to kids? A better way to state this is no playing, loitering in the stairways, hallways, etc. This way, it's not just at kids; it's at adults too. So if you have a group of adults they like to go out onto into the hallways and have a beer, talking, that's loitering in the hallways. That is an inappropriate use, and unfortunately, you're going to have to get at this equally. And if you adopt a rule that says no loitering in the hallway, stairways, etc., it means you got to go with the adults to do it too. And I know a lot of these rules are because kids tend to be noisy, kids tend to be loud, kids tend to run, scream, yell, jump on the halls, on the stairs, making it very loud and unpleasant living experience for people without kids. Unfortunately, there's no way around it. It's either all or none. You can state hallways are not to be used for loitering, running, jumping, yelling, screaming. That is gets at everybody. It gets at the adults who come home and yell and scream when they get home and tell their people to come down and help them unload the groceries. That's just not appropriate use of the hallways. Hallways shouldn't be run in. Hallways shouldn't be allowed to be a cavern of noise. Don't just limit it to kids. Okay. Rules can unfortunately be discriminatory even if they're unwritten. And you have a board that has an unwritten policy to visit every owner that places his or her unit on the market and encourage them to sell to a family without kids. It has a disparate impact based on familial status. It's an unequal treatment of children under the 18, unequal treatment of pregnant women, unequal treatment of families based on size or content. It was unwritten. It was just a habit of the board, and unfortunately, it got out, and that is an actual case. It got out. Somebody was encouraged to sell to family without kids, and the gave rise to a claim of discrimination, and the board was found liable because it was unwritten. Nor did it say we do this. They did it, and it cost them a large sum of money, well over $60,000 in fines, because it had a discriminatory impact, and they were not allowed to try and keep kids out of the unit or out of the community. I know we were made aware of a situation in which, a member of the board of directors just actually happened to own the unit in the community, and they advertised the unit ideal for 1 or 2 adults. And the state caught wind of that. I don't know how the state actually caught wind of it, but they caught wind of it, and they shocked the guy. They came up and called and said, "Hey, I see you have this unit on the market. Like to look at it." And the guy said, "Well, it's really kind of small. You don't have any kids, do you?" And the person said, "Oh, no," and just hung up. also had a sign on that said no pets allowed. And state called again. One of the investigators at the state called again and said, you know, I'd like to rent your unit, have a small dog. And the guy said, nope, no pets, click. End of the story. And within a week was served with a lawsuit for 2 violations based on discrimination, in that it's not the owner's decision as to whether or not a family can live in the unit, and it's not the owner's decision not even to allow for an owner to request a reasonable accommodation. And again, it ended up costing that owner quite a bit of money, having to defend those 2 lawsuits from the state. And the state is actively out seeking these things. So again, you cannot have rules, you cannot enforce these policies against individuals. You have to at least investigate. You have to perform your due diligence. And like I said, discrimination occurs at the time of enforcement. And when the owner said it's not big enough for 2 people and hung up, that was enough for the state. Okay, our docs say, any rental, lease, or sublease shall not allow more than 5 tenants as occupants of the unit. Is it discriminatory for a housing violation because it does not apply to the owner occupied units? Yes, it's discriminatory. Now, normally I would say tenants are not a protected class. Unfortunately, familial status, the formation of the family is a protected class. And if you're not even looking at it and just say, any rental, lease, or sublease shall not allow more than 5 tenants as occupants of the unit, that's discriminatory, because the unit may be a 3-bedroom, and under anybody's stretch of the imagination it works, or you are now defining what a family is, and not based on anything other than we don't want more than 5 tenants in a particular unit. So yes, that is discriminatory. I would not try and enforce that at all. It becomes very problematic. That's a very good example too of disparate impact. It doesn't say certain things, but it is intended to get at families. Okay, pets. Owners may have up to 2 domesticated dogs, cats, or any combination thereof. Renters may not have dogs. Okay, going just exactly what that question says. Are there problems with this? Well, the problem, as I mentioned, renters are not necessarily a protected class, and you can come up with a litany of reasons why you don't want renters to have pets in the community. One, they don't take pride in ownership. They tend to let their pets run around, and they don't clean up after them. They're not responsible for the damage. Is it discriminatory on its face? Is this rule? Not necessarily, because again, being a tenant in and of itself is not a protected class. Could this policy have a discriminatory effect? Of course it could. If you are preventing somebody from having a dog without even looking at the situation, it could be an emotional support animal. And I know we all know and love the emotional support animal conundrum, but on its face, if you are just blatantly not investigating it or not allowing somebody to come in and say, I need this animal, it's an emotional support animal, or it's an ADA qualified service animal. Those are not pets on their face. But you have not said renters may not have pets, you've said renters may not have dogs. So it becomes problematic. It does have a disparate impact. Even though it's neutral on its face, it may impact a protected class. The moral of the story on this particular one is that no intent is required. You don't have to intend to discriminate. It's just how it has that impact. Does it have a discriminatory impact? And it could give rise to a claim of discrimination, which really is problematic for a number of reasons, which we'll get into. Okay. Again, what about emotional support animals? Emotional support animals have become the bane of everybody's existence. And it's because you don't necessarily have to be handicapped. You have to have a physical and mental impairment which substantially limits a major life activity, such as walking, seeing, hearing, working, caring for oneself. And unfortunately, that being the definition of what a handicap is or a physical and mental impairment is, it includes this concept of stress and anxiety and needing an animal to help support you emotionally. And the FHA, this is the concept of an ESA, is a creature of the FHA, the Fair Housing Act, not of the ADA. The Americans with Disabilities Act, which for the most part does not apply to community associations other than you must allow a service animal. And when I say a service animal, an Americans with Disability Act service animal is either a dog or a miniature horse. And it must be trained. No, it does not have to be professionally trained, but it must be trained to perform a specific task to alleviate a disability. That, by definition, is an an ADA animal, a service animal. An emotional support animal, on the contrary, does not have to be trained to perform a function, either professionally or individually. It just has to alleviate a condition. But there does have to be a nexus between the need for the animal and the disability, or what the animal does. And there are a couple cases on point about this, and one of which is, a nice old lady who had a dog, and you could sit there on a number of levels have said this is an emotional support animal, but she never came out and said, well, this animal, I have this condition and this animal does this. And the court, in looking at, giving her every possible chance to say this is an emotional support animal, she never did. She said, well, does it relieve stress? No, I just like the dog. Does it do this? No, I just like the dog. Does it do this? No, it doesn't do this. And the court had to find that it was not a qualified emotional support animal. It's like the only case in the world on it. But this particular owner, I would say, was probably only one of the truthful, ethical owners out there that had emotional support animals. And flat out said, no, it doesn't do any of those things. I just love the dog. And the court had to find that. So again, the difference between an ADA animal and a emotional support animal is very different. The emotional support animal also does not have to be a dog. It can be a cat. And you've seen the stories of emotional support chickens, which again, I think we can push back on emotional support chickens. But it can be anything. It's just anything that allows the owner of that animal to cope with daily life activities. All right. What about these? Occupancy restrictions. And I know this question just popped up. I hate occupancy restrictions. A restriction that says the unit may only be used by a single family, which may include one husband, one wife, and natural or adopted children. Is it discriminatory? Absolutely. It is. Because it requires marriage. Doesn't allow for domestic partnership. Doesn't allow for live-ins. And may discriminate based on a sexual preference. Now, this is kind of old. All the cases have not quite caught up with the fact that marriage is legal, domestic partnerships are legal for homosexual couples. But that's really what I was trying to get at. Those type of rules of a husband and a wife, flat out discriminatory on its face. It also tries to define what a family is. And occupancy limits are generally problematic. I always recommend, again, get at behavior. Occupancy limits are also very, very difficult to try and prove. And we have a question that says, can an HOA specifically tell owners that the children cannot play in front of their garage? Children have adult supervision at all times. Boards are claiming safety and noise. And basis for the rule, communication is specifically called out. Children threaten fines. No, that's discriminatory on its face. If it says it calls out children, it says children cannot play in front of their garages. Children have adult supervision at all times. Why do they need adult supervision at all times? Again, if somebody's allowed to babysit at the age of 15, that's supervision. You can't have adult supervision. Competent supervision, you can slip into the rule, say, again, it's got to be competent supervision, cannot be adult supervision, cannot require adult supervision. The other problem is, and there's actually, again, a case on point. So this is a federal appellate court case where the association adopted what you and I would call what sounds like a very reasonable rule of children can't play in the parking lot. And family sued, saying you cannot adopt and enforce a rule that children can't play in the parking lot. Of course, the HOA went, what? There's life, health, safety. It's a parking lot. And what the court did is they looked at the community as a whole. And they said, please tell us exactly where kids are expected to play in this community. And the association kind of looked around and said, well, there's no place to play. And the court came back and said, exactly. Therefore, this rule is discriminatory. There's no place for kids to play, so you have to let them play in the parking lot. Make it work. And it was an unfortunate situation in that there really was no place for kids to play, and they had to be allowed to play someplace, and therefore they had to find a way to make the parking lot into a playground and measure those competing interests. So in your particular question of children cannot play in front of their garage, I think if there's absolutely no other place to play and it's their garage, there's absolutely nothing you can do about it. I understand that noise is their basis. Noise is not a valid basis for a rule. It's just not, other than quiet hours. You can't have one that says kids can't be kids. It has a disparate impact against kids. So that rule is going to be deemed unenforceable. Sorry. Next one is, just to be clear, the decks cannot limit the number of people per bedroom. Again, let me go to the next slide, see what it says, make sure I'm not going to address this. All right, that deals with group homes. So we'll come to that rule. Code, the individual cities and individual municipalities have tried and have been struggling with that concept for forever, is to how many people can live in a unit. And cities have gone to square footage, no more than one person per every 100 square footage or something along those lines. Kills the concept of a tiny house. They've gone to no more than 2 people per bedroom, plus one. It's 2 people plus one. It's kind of some of those things, but those appear in code. And I have always recommended, again, who is it? Why should the association care how many people live in a unit or live in a home? If the county's not going to enforce it. Plus, you have a problem where the counties call it, or the municipal entity, code enforcement calls it, trying to come in and count toothbrushes, because you never really know who's living there. I mean, you're going to get a good idea, but it's this concept of, is the person a guest? Do they actually live there? Are they in and out of the unit? But again, what does the association care of if they're a quiet family, or if they're not causing problems, or if they're not causing parking problems? I've always recommended, and it's my advice, to not necessarily enforce a capacity restriction, but get at the behavior. There are 17 people living in this unit and it's causing parking problems. We'll get at the parking problems. Or there are this many and it's causing noise problems. Get at the noise problem. Get at the nuisance. Get at the disturbance. Don't try and say you have too many people. Let the county enforce that restriction. I don't want you trying to enforce that restriction. It just leads to, it's wrought with peril. As you're going to see in this next slide, the association of the following provision in this declaration: homes shall be used for single family purposes only. No business of any kind may be conducted from a home. And inevitably, a group home is going to try and move into the neighborhood, and the association wants to prohibit it based on the above covenant. I will tell you, it's discriminatory. The courts have protected these group homes, whether it be a group home of kids, or a group home for Alzheimer's patients, or a group home for recovering drug addicts. Those are all protected classes, being kids, being adults, mentally disabled adults, being Alzheimer's, or the the illness of being a drug addict. Now, the restriction applies to a recovery center. If somebody is found not to be in recovery but is an active user in that home, that particular user is not protected, because the act of using drugs is not protected, but the act of recovery is. The state of Colorado has also looked at, everybody kind of looks and say, well, it says single family. And by definition, if you have a group of unrelated individuals living in that home, that is not a single family. The court looked at this, and the seminal case on that is called Doubleday Manor v. I forget the name of the association. I apologize. We all just refer to it as Doubleday Manor. But what it said is the court looked at it and said it was a corporation that bought a couple homes in a community for wayward boys. And they moved the boys into the homes to give them a loving structure and give them ability to stay in school. And the court looked at it and said, okay, let's really take a step back and look at what's going on in this home. And what do families do in their home? Well, the families cook dinner. And the court looked at it and said, here, this group of boys cooks dinner. They're supervised, they cook dinner. What else do families do? They have dinner together. Well, they're having dinner together. It's a requirement of this program that they all sit down and they have dinner together. And then the court looked at it and said, okay, what do families do? Well, they do homework in the house. And what are these boys doing? They're doing homework in the house. So the court looked at it and said, single family refers to the type of structure. It does not refer to the actual use. And that has been the rule in the state of Colorado ever since. Is it a single family structure versus a multifamily, meaning a condominium or a multifamily building? It's the structure. So when you see these single family purposes only, read, is it a single family home? Not anything else. It's you can't get at that. Now, the business piece, it is the business of operating these facilities that has the kind of that new line of challenge to it. And the courts have just thrown it out saying, we want to encourage these type of uses. We want to encourage Alzheimer's homes. We want to encourage wayward homes for children. So therefore, no, we want to include these in these communities. We want them embedded in these communities, and you cannot restrict them. Trying to get at that use is a losing argument, and it will just cost the association money to end up in the exact same place. And then the question is, I'm not asking about lifestyles, just limiting the number of people in the bedroom. And again, as I mentioned, I don't like it. I understand the whole lifestyle argument, but I understand the number of people in the bedroom argument. But again, what is gained by trying to enforce that particular rule? I think it's problematic. It's just wrought with peril. Leave it to the county to try and enforce an overcrowded home. The association should get into behavior, not at that. It's wrought with peril. And the association will end up spending a whole lot of money and probably end up with an answer it does not want. Okay. Is it okay for an HOA to ask for medical documentation of an emotional support dog that the member wants? Well, we have to have while at the pool. The HOA has a rule: no pets at the pool area. Should the dog be allowed while waiting for documentation? Yes, the dog should be allowed for waiting for documentation. The rule for an emotional support animal, the FHA emotional support animal, is a reasonable accommodation to the rule to allow the owner to keep the pet. I believe that you could still restrict the pet from the pool area for sanitary reasons, unless the owner can show by reliable medical information that that dog, or that, in this case, the dog, must be with that owner at all times. It's including at the pool. I would ask that you get reliable medical information saying, yes, this owner must have this, or this pet owner must have this dog while at the pool. Otherwise, I think you're well within your bounds trying to remove it from the pool area, because again, the accommodation is to allow the owner to keep the pool in the facility or in the home, or in the community, not necessarily at the pool, which violates any number of other rules and the like. So I think you have sufficient authority to push back on that and actually ask for the medical information related to pet at pool. Because again, there has to be a nexus between the disability and the accommodation. And unless that accommodation is, this person needs this at all times, particularly around water because they're afraid of drowning, and well, okay, then we lose it. But at the same time, are you allowed to ask for that? Of course you're allowed. Yes, you are allowed to ask for it. Okay. Let me get to talk about that. Religion. Okay. The association has a rule that nothing may be placed on the exterior of a door. Owner requests permission to place a small religious symbol on the door. The association denies. Up until June 30th of this year, that was fine. As long as you discriminated against all religions, not just one, but all religions, or you discriminated against everything being on the outside of a door, you would have been able to do that. However, the state of Colorado and Governor Polis just signed on June 30, 2020, the HOA Information Resource Officer Bill and Religious Freedom Bill. It violated state law and the state constitution on a number of different ways of how that got adopted, but Governor Polis didn't care. He signed it anyway. So now you are prohibited from discriminating against religious symbols on common element doorways. It can be no bigger than 6 by 6 inches, has to be related to a sincerely held religious belief, but you now must allow these. This really relates to mezuzahs. It's a small little prayer container that goes on that door jamb on the outside of a unit and the common elements in the condominium, and you must allow it. Okay. Question is there a template for sending out violations to owners? Yeah, go ahead and give me an email and we can talk about it. And it says, is there a template for sending out violations to owners, residents that allow for a violator to have an opportunity to defend their reason for the violation? I having a pet. Would this be different from a clause regarding notice in a hearing or right to the hearing? We have recommended the association adopt a emotional support or a reasonable accommodation policy, which walks the association how to handle these requests without getting themselves into trouble. Yeah, you can email me, we can talk about it, and we can get that done. Excuse me. Oh, talking without getting a glass of water. All right, discrimination based on religion. You had no duty to accommodate as it was not a handicap. There's a duty to treat all religions the same and remain neutral with all religions. Examples, clubhouse may not be used for any religious activities. That's fine, just discriminating against everybody. As opposed to a rule that says the only permitted holiday decorations are Christmas lights. If you have a rule that says Christmas lights may be put up the Friday after Thanksgiving and removed January or the first Saturday after January after New Year's, that is a discriminatory rule. You could put holiday decorations or holiday lights may be put up. That way you're not being discriminatory in favor of Christmas lights. You need to make sure, and again, a lot of this is just in the wording of the rules. You may get the exact same setup, but you need to make sure you're not discriminating in favor of Christmas. It's got to be holiday lights. It's got to be winter lights. It's got to be, there are other holidays set up at different times. Again, you just need to make sure your rules are religious neutral or holiday neutral. Okay. Risks. How do you minimize your risks? Well, you keep good records. Make sure that you are keeping good records, that you ask the same questions to everybody. Make sure you're not discriminating against one person over another. Be consistent. Make sure you're adopting your rules in a uniform, non-discriminatory manner. It's the only way you can do it. Take all requests for reasonable modification and accommodation seriously. Now, we didn't really talk much about modifications. And modification can be done at the owner's expense. And really what that is that's a modification to common elements of the exterior of a home to accommodate somebody's physical disability. And really where it comes into play is if somebody asks for a wheelchair ramp. You can't just deny a wheelchair ramp. You actually have to consult it. You can say that a wheelchair ramp can only be built here, or a wheelchair ramp must contain these certain things. Make sure you're just treating these equally. Consult your legal counsel if you have questions. Work through these issues and work through these questions, because it really does become problematic when you just uniformly deny a pet or uniformly deny a dog. And I know the first gut reaction out of many people is they're just lying, or this is no pet building. People moved into this building so they don't have to deal with pet dander. Where's that balancing of the rights of the other owners that moved into a building to be pet free, and that they don't have to deal with this, versus somebody that moves in and wants to have a pet and they bring it in. Make sure you are walking through these steps. Make sure you're discussing with legal counsel. Make sure you are handling these issues. What about an owner requesting a stair lift on common elements? And you're going to have to allow it. If it is the only way that the owner can fully realize the use of their property, and it's signed off on by all relevant entities. I had a situation once where the owner came in and lived on a third floor unit and wanted to install a chairlift all the way up around the exterior common element hallway. And I thought we'd be able to get out of it because the fire marshal would say, no, it takes up too much of the common area and it eliminates fire access. Well, unfortunately, the fire marshal came back and said, nope, you've got this secondary exit point for ingress and egress, and go ahead. And the association had to allow it. Now, we put certain conditions on it, saying, again, if you're going to install it, it becomes the association's property. Modifications to the common elements, while you can require the owner to pay for them, the association has to maintain it. It becomes association property. And being association property, they can remove it as soon as it's no longer needed. So in that particular case, we discussed that, that owner could keep that in place for her period of ownership of the property in case she wanted to move out and rent it to somebody with a disability. But the association, had to take that into accommodation and actually had to allow that stairway and or the stair lift and had to keep it in place for as long as that owner owns that property. It's crazy, but that's what the owner wanted to do. Rather than sell their unit and move to a ground floor, they wanted to install a $25,000 chairlift. Go figure. Okay, the where. Where does all this happen? And this is, in our investigation on this, well, it's through the Colorado Civil Rights Division. An owner or a person feeling discriminated against can file a complaint with the Colorado Civil Rights Division. They will pick up that cause free of charge, and they will investigate for that person. And I tell you, the Colorado Civil Rights Division is not your friend. They are looking for a violation. They want to advocate for this complainer, and they are not a neutral party. They will advocate for that person. They will investigate. And the second you get a letter from the Colorado Civil Rights Division, I would absolutely call your attorney and make sure that they are well aware of what's going on and they can help you provide a defense, because they are going to get all up in your business and they're going to want all of your records. I told you in the previous slide, keep all your records. Well, you keep all your records as to how you treated these in the past, what you've done, because what's going to happen is if they find a violation, if they find a probable cause, they're going to require fines. They're going to require board members to attend a re-education camp, educational opportunities, anti-discrimination classes. They're going to have reporting requirements. They are going to get in and stay in your association's business. It's no fun for anybody. After the CCRD, they can bring a lawsuit in the district court for either the county where the property is located or the federal court. These are federal claims. They have multiple paths to claim, and they get very, very expensive very, very quick. So make sure that, again, you're documenting everything. You're documenting when you received the complaint. You're documenting how you responded to it. You're documenting what you asked for. You're documenting when you actually took that on. Okay? And then, as I mentioned, these are all resources. Please go to our website. There are a ton of resources on our website, articles we've drafted, LinkedIn, Twitter, Facebook. We're on Facebook. It's great. We also have a YouTube channel. Please look for our YouTube channel. Okay. And how you can contact me, please just send me an email. Anybody that needs it, or email Grace. I gave you her email at the beginning of it. Grace, let me make sure I did. education@altitude.law. Please educate, send us an email. We're more than happy to respond. You can get the PowerPoint, you can get answers to some more of your questions, and we can talk about that policy that you may or may not need. And with that, any other questions? I will stay on for a few more minutes and answer any questions that anybody may have. And again, I thank you very much, everybody. It has been an absolute pleasure. Might have missed my answer to the question above. Hang on, let me look for it. I'm not asking about the okay. You asked. I'm not asking about the lifestyle, just limiting the number of people in the bedroom. I had mentioned. I don't recommend that you try and enforce occupancy restrictions. Leave it to the county or the municipal entity. It becomes very problematic in trying to establish the association's interest or damage if they are not causing problems in the community. If they're causing problems in the community, that is a different course of action as opposed to dealing with too many people in the home. And like I said, it's just something we don't recommend. Leave that to code enforcement, leave that to zoning, leave that to the county to investigate. That way you keep your hands and the association clean, as opposed to getting involved with trying to enforce something that, again, you may end up not getting the answer that you want to get. Okay, here we go. I know it's not allowed to impose adult-only swim time, but what about restricting times for specific activities? For example, in the mornings allowing lap swim, that's perfect. Or exercise activities in the afternoon hours or more playtime. None of these are age. I love that. Yes, you can have a lap swim only. You're not discriminating against anybody. You are saying this particular use is all that's going to be happening. Or if you have jazzercise classes, or if you have water aerobics type classes. Yes, you can have activities. You can absolutely limit the pool to activities such as lap swim and then playtime and then this and this and this. You absolutely can. That's fine because you're not discriminating against anybody. And I do apologize for not making that more clear. Thank you. Do you think the recent HOA bill signed will be challenged in court for violating the state constitution? No, I don't. I don't think it matters enough to anybody that he signed it. The religious freedom bill was probably going to pass anyway. It is merely because it was at the end of the session. They wanted to get it in, and they couldn't run another bill. So they just threw it in it because it kind of sort of involved HOAs, but it in my opinion, it violated the Constitution for single topic, because what does religious freedom versus the HOA information resource officer have to do with each other? The name of the bill was the HOA information resource officer continuation, or the sunset of the HOA information resource officer, and they just tucked it in. I think if somebody did challenge it, it would probably be a winner, but I don't know if anybody's that interested in to challenge it. Sorry.